Court rise if able. These appeals are in the matter of Mace Ltd and Riverstone Managing Agency Ltd and others, and Sky UK Ltd, Riverstone Managing Agency Ltd and others.
Yes, Mr. Edwards, can I just say one or two things before we start?
Of course.
First of all, thank you very much for the reading list. So that you know, we've read what was designated as essential reading. Speaking entirely for myself, I've got no further than that, I'm afraid. I haven't looked at what was described as desirable reading, and I haven't looked at any of the authorities. Thank you very much for the agreed timetable. Again, just so you know, 1 p.m. Friday is a hard stop. We hope that'll be plenty of time, but you'll tailor your submissions accordingly. Thank you very much for accommodating my requirements for single-sided bundles. It's not very easy because people have different preferences. I would say for future reference that there are members of this constitution who prefer double-sided and there are those who prefer single-sided. And it's always worth asking the office before the bundles are prepared, if possible. Sometimes they're prepared before the constitutions are known, but usually the authorities' bundles, for example, are prepared afterwards. I just say that for future use. All right, off we go.
My Lord, very well. My Lords, I appear with Mr. Winsor, King's Counsel, and Mr. Carr for Sky. Mr. Reid, King's Counsel, appears for Mace with Miss Allain and Mr. Shaw. And Mr. Rigney, King's Counsel, appears for the insurers, Riverstone and others, together with Mr. Goldstone and Mr. Maxwell. My Lords, as you will have picked up, these appeals concern claims by Sky and by Mace under what is described as a contract works and special provision terrorism policy in respect of widespread damage to the roof of Sky's headquarter building in West London. It's called Sky Central, caused by water ingress into the roof during construction. The claims, again, as you know, were the subject of a 5-week trial before His Honour Judge Pelling KC. The broad effect of his judgment and his order is that Sky was entitled to be indemnified in respect of the damage to the roof by reference to what was referred to at the trial as Insurers 2018-19 scheme, subject to 4 modifications. And the judge, as you have seen, ordered that the financial impact of those modifications should be dealt with at an assessment of damages hearing, with insurers making an interim payment of around 38.6 million in the meantime. In terms of the appeals, there are 3 appeals before you. There's an appeal by Sky, an appeal by Mace, and an appeal by insurers in the Sky action. Sky's appeal concerns the judge's main trial judgment, and that's in your core bundle B at tab 15A. The appeals by Mace and by insurers will also involve consideration of the judge's 2 post-judgment rulings, which you'll find again in core bundle B in tabs 15B and tab 15C. In giving permission to appeal, Lord Justice Mayles directed that the party should agree a timetable, and my Lord Justice Popplewell has already commented on that. As you will see, the plan is very broadly that Sky will make submissions in support of its appeal today, and Mace in support of its appeal tomorrow morning. Tomorrow afternoon and on Thursday, insurers will respond and make submissions in support of their own appeal, and there will then be responses and replies. So subject to the court's views, that's the course we propose to follow. So far as Sky's appeal is concerned, permission to appeal was granted by Lord Justice Mayles on 8 grounds. Grounds 1 to 3 and 4, which concern the period of insurance and investigation costs. They raise what are essentially issues of policy construction and or of law, I will deal with those, and that is likely to take up around about 2/3 of our time today. Mr. Windsor will deal with ground 5 and with grounds 7 to 9, which concern certain of the judge's findings of fact. My lords, all 8 grounds have this in common. They suggest that the judge's rejection of the Sky and the Mace schemes and his decision to use a modified version of insurer's 2018-19 scheme as the basis for quantification of the indemnity to Sky is wrong. Now, although the precise number remains to be determined, the likely effect of the judge's decision is that Sky will recover some tens of millions less than it considers is required to reinstate the roof to its pre-damage condition. In terms of remedy, as your lordships will have seen, and as reflected in our notice of appeal, we anticipate that if our appeal is successful, then the matter will need to be remitted to the judge to make findings in accordance with the Court of Appeal's judgment. Now, my lords, with that very brief introduction, can I turn then straight away to grounds 1 to 3, which, as I said a moment ago, concern the period of insurance. They concern the judge's conclusion, which you'll see in paragraph 75 of his judgment. It's Core Bundle B, tab 15A, page 383. His conclusion that at the end of the period of insurance, there was what we have termed in our skeleton argument a hard stop, such that insurers were only required to pay for the remediation of physical damage to the roof as it was at the 15th of July 2017, and they were not required to pay for any development or deterioration of that damage thereafter under any circumstances. So when I use the term hard stop, that's what I mean. The significance of the point is that, as you will see from paragraph 182 of the judge's judgment, the judge's conclusion that there was such a hard stop was the principal reason for his rejection of the Sky and the Mace schemes, and for his decision that the indemnity to which Sky was entitled was appropriately quantified by reference to a modified version of insurer's 18-19 scheme. If the judge was wrong about the hard stop, as we say he was, then his rejection of the Sky and the Mace schemes is substantially undermined. Now, my lords, what I've just said is subject to 2 qualifications. The first is this: the causal significance of any development or deterioration of damage between the 15th of July 2017 and the end of the drying out works in August 2019 is presently limited in light of the judge's finding at paragraph 157 of the judgment that any deterioration or development of the damage between those dates would probably not alter the type, scale, or cost of the remedial work required. Now, as you may have picked up, the insurers sought to appeal against that finding. It was their ground 3, but they were refused permission to do so. The second qualification is this.
You say the causal significance is limited. Is there any causal significance?
Well, in relation to that period,
Yes.
not at the moment, so it seems. I mean, I'll obviously wait to hear what my learned friend Mr. Rigney says, but at the moment it would seem that the answer is no, subject to other points in relation to our own appeal, but there is that particular issue. Well, the other qualification is this: the significance of the judge's conclusion that there was a hard stop on the 15th of July 2017 may be affected by your decisions on other aspects of the parties' respective appeals. Now, so far as Sky's appeal is concerned, even if the judge's decision about a hard stop was correct, which of course we say it was not, there are other aspects of his judgment which we say make his decision to reject the Sky and the Mace schemes difficult to justify. Those are the subject of grounds 5 and 7 to 9, which Mr. Windsor will address later. If Sky's appeal on those grounds succeeds, the position in relation to grounds 1 to 3 may become less important. Grounds 1 to 3 may, I accept, become more important in light of your decision in relation to insurer's ground 1, and that is the insurer's appeal concerning the judge's conclusion as to what constitutes physical damage. I accept that if the judge's conclusion on that matter were altered by this court, then the temporal questions embodied within grounds 1 to 3 might become more important. So that was the two qualifications I wanted to make in relation to significance. My Lords, in order to put the issues raised by grounds 1 to 3 into their proper context, I wanted to start by explaining very briefly the factual circumstances in which the issues arise. There are 4 points I wanted to make. The points are uncontentious. They were either common ground at trial, or they concern findings made by the judge that are not challenged, or they are contained in the agreed chronology of events that you'll find in Core Bundle B, tab 13. So, my Lords, 4 points, if I may. The first point concerns the nature of the cassettes making up the roof of Sky Central. And for your note, it's a matter that the judge addressed in paragraphs 5 to 11 and also paragraph 117 of his judgment. The roof of Sky Central was made up of 472 prefabricated cassettes, 428 installed on the main roof, and the remaining 44 on what are called the plenums, which are around the 6 service cores. And as the drawings that appear quite early on in the judge's judgment at paragraph 8, as those drawings show, each cassette was made up of a number of bays or compartments, the lowest compartment being the gutter, and the compartments above that referred to as the eaves. There are, just so that you know, around about 5,000 compartments on the roof as a whole. The cassettes were manufactured in Austria.
And when people refer to the upslope, that's the whole of it apart from the gutter, is it?
Correct. And I'm going to come on to this in just a second, but the roof is referred to as nominally or notionally flat. The gutter compartment, the gutters are flat. Actually, upslope of that, there is a 2-degree slope.
That would make sense.
It would. As I was in the course of saying, the cassettes were manufactured in Austria. They were then transported to and finished at a location near to Sky Central. They were then brought to the site. They were lifted onto the roof using lifting strops that were attached to the cassettes. And they were then installed in place. And sometime later, they were the subject of permanent waterproofing using a Derbigum membrane. Now, I made the point a second ago that although referred to as flat, upslope of the gutters, the roof, in fact, has a modest 2-degree slope. What that means is obvious. Any rain will run down the cassettes and into the gutters. And there are 2 types of gutter. There are valley gutters and perimeter gutters. Perimeter gutters obviously being around the perimeter of the roof. But in the gutters, the water will pool. Once the roof is complete, water is intended to drain away from the gutters by a siphonic drainage system, once the roof is complete. Now, my Lords, as the judge found, and this is paragraph 117, the first sentence, the cassettes were manufactured and delivered to Sky Central free of any internal moisture, that is, aside from the moisture that would be, in any event, inherent within the wood. They were designed and intended to remain in that condition, moisture-free, for the remainder of their useful life. And as insurer's wood science expert, Mr. Coulson, explained in his report, and this is not disputed, because the cassettes were designed to stay dry, no preservatives had been applied to the timbers. If you need the reference, it's paragraph 6.19 of Mr. Coulson's report, Supplemental Bundle D, tab 42A, page 693. It was a feature of the cassettes, and this is described in the judge's judgment at paragraph 6, that the timber and the insulation components were encapsulated by a vapour control layer, which was laid across the underside of each cassette and then folded up the side, with, of course, a Derbigum membrane on top. All of that effectively created a basin or a bathtub around the cassettes. And the result would be that any unwanted moisture that got into the cassettes, certainly beyond a very modest amount, would be entrapped and would be unable to dissipate naturally. And well, that's my first point. The second point concerns the timing of the installation of the cassettes on the roof. And the judge dealt with this in paragraphs 12 and 13 of his judgment. The cassettes were installed on the roof in zones on dates between December 2014 and May 2015. They were then left waiting for permanent waterproofing. The judgment doesn't deal with this, but the agreed chronology of events, if you wanted to turn it up, it's Core Bundle B, tab 13, page 339. That document explains that most of the cassettes appear to have been finally waterproofed by mid-August 2015. So installation on the roof on dates between December 14 and May 15, final waterproofing complete August 2015.
And was the Derbigum waterproofing done zone by zone as the zones were completed, or was it done after all the zones had been?
The answer to that, I'm afraid, I don't know, my lord. I can certainly make inquiries.
It may not matter. I mean, were they sitting exposed
I'm
to
told
the weather
for
for at least 5 or 6 months, or not necessarily?
I hear voices from many sides telling me that it was done zone by zone, and you're absolutely right that means that what one, as it were, cannot know exactly how long a particular cassette was left out in the rain. Any cassette installed in December 2014, which happened to be only waterproofed in August 2015, would obviously have been exposed for more than 6 months, but we don't know. There's a gap. There's a temporal gap between the dates when the cassettes were installed and permanent waterproofing.
Thank you.
Well, the third point concerns the time at which and the route by which water entered into the cassettes. And that's dealt with in the judge's judgment at paragraph 8, paragraphs 13 to 14, 159, and 167 to 168. What you will see if you look at those paragraphs is that, drawing on the evidence of Dr. Poole, and he was the jointly instructed causation expert put forward by Mace and by Sky, that drawing on his evidence, the judge described in paragraph 13 of his judgment the rainfall that occurred between the time when the cassettes were installed on the roof and before they were permanently waterproofed. The judge records the unchallenged evidence of Dr. Poole that at or above a specified depth of rainfall, water would flow down the Derbigum-covered surface of the cassettes, over the holes left by the severed lifting strops, and then into the gutters, where water would accumulate prior to permanent sealing and the connection of the gutters to the downpipes.
Can you just help me by reference to the helpful photo in the judgment? Where are the holes left by the lifting strops?
Well, there are between four and six holes on each cassette. I don't know the answer to this in terms of whether they're identically located, but they are obviously located in areas where you can pick up the cassette using a crane.
They're somewhere on the upper surface of the upslope, are they?
Correct. And one of the things we'll come on to, and Mr. Windsor will probably deal with this later, is that although it's certainly right that the majority of the water damage, the majority of the water ingress and the majority of the water damage affects the gutters. There has also been damage in isolated areas of the upslopes, in particular around areas where there were lifting strops which are cut off and then not properly protected. So yes, my lord, I believe you are right that you've got between 4 and 6 lifting strops per cassette, located certainly some in the upper compartments. My lords, just going back to the judgment, in paragraph 14, the judge found that it became apparent from an early stage, by March 2015, that rainwater had entered into the cassettes, with standing water found in some gutter compartments. The judge records that there were some attempts at drying out in 2015 and 16, but that by the end of the trial, it was common ground that those attempts were at best only partially successful. The principal route by which most of the water entered into the cassettes, the judge found at paragraph 159 of his judgment, was that identified by Dr. Poole, namely through a gap between the membrane and the bottom of the gutter upstand, which existed before permanent waterproofing was installed. If it helps you, my lords, to visualise that, you might look at the photograph in Dr. Poole's report. It's figure 121, which is supplemental bundle D, tab 45, page 784. And my lords, just whilst we have this bundle open, perhaps you can go back to page 758, and I may be able to answer my Lord Lord Justice Popplewell's question. If we can start at 758, if you look at the figure 43 in the top right-hand corner of page 758, you will see some arrows which indicate the location of lifting strops. So you can see there, as it were, distributed around areas of the cassette. And there are some more pictures or indications, figure 42 and 45 as well. I was going to take you to page 784, if I may. This is a photograph that was taken as part of a mock-up exercise that was carried out by Dr. Poole. But if you look at figure 121, the gap that we are talking about, it is the gap, as it were, just below the near right angle bend of the Derbigum that you see. And if you look back on the preceding page, page 783, you will see another photograph. This is figure 120, and this is not the mock-up. This is actually, I think, a photograph taken from the roof itself. And there you will see the gap indicated. So that was the principal route which the judge, or by which the judge found most of the water entered into the cassettes. Now, my lord.
So I see. So it's a gap in the 90-degree angle at the sides of the gutter, not at the, not
Yes.
where the gutter meets the upstand. I've
Yes.
misunderstood that. Thank you.
Yeah, the upstand is the. You're looking at figure 120. The upstand is the piece of timber to the right. The floor of the gutter is the bit in the foreground at the bottom of the picture. And as you say, the Derbigum is folded, and the gap exists just below the near right angle turn.
Yes, thank you.
So that was the principal route by which the judge found water entered into the cassettes. There are 2 points which it is important for you to note in relation to the judge's findings in relation to water ingress. My lords, the first is that in paragraphs 168, 170, 171 and 174 of his judgment, the judge rejected the evidence of insurer's causation expert, Mr. Jessup, that water had entered into the cassettes as a result of random construction errors or through defective laps at joints between the cassettes. Referred to, I think, at trial as Mr. Jessup's lap theory, and it was something which Mr. Jessup said had given rise to water ingress both during construction and after it. And one sees that in, you don't need to turn it up in the causation expert's joint statement. As the judge identified, or sorry, as the judge observed, Mr. Jessup had not been able to identify any instances where water had entered into through that route. That's what the judge found at paragraph 174. The second important point for you to note, this is paragraph 150 of the judgment, core bundle B, tab 15A, page 409, is that the judge was not prepared to accept the evidence of insurer's wood science expert, Mr. Coulson, that there was continuing water ingress into the roof after completion of the permanent waterproofing. Now, Mr. Windsor will deal with this issue in more detail in the context of ground 5 later on today, but there is no finding in the judgment that there was any significant ingress of water into the cassettes after construction. The most that one finds is the reference in paragraph 175 of the judgment to a small number of instances of minor localized entry of water through insufficiently sealed vent housings or patch repairs.
So just give me that paragraph number again.
175, it's, if you have the judgment open in the bundle.
Don't worry, I don't need to go through it, I just want to make a note of it.
Yes,
Thank you.
175. My lords, there's one more factual point that I want to make. That, if I may, I just want to pause to take stock of the effect of the 3 points that I've made so far, bearing in mind the period of insurance. The period of insurance commenced on the 1st of February 2014. It ended on the 15th of July 2017. The dates are in paragraph 27 of the judgment. As the judge explained, in paragraph 27 and again in paragraph 68 and again in paragraph 115, the insurers were, quotes, content for the purposes of these claims to treat the period of insurance as being the whole of this period without distinguishing between the initial and the maintenance period of insurance. So, as you'll see, the insurers advanced no argument about the significance of those two aspects of the period of insurance at trial. They advanced no argument about it now, nor could they. What the 3 factual points that I've made so far demonstrate is this. What we are concerned with in this case is physical damage caused by water entering the cassettes prior to the completion of permanent waterproofing works in August 2015, and therefore inevitably prior to the end of the period of insurance on the 15th of July 2017. We are not concerned with physical damage caused by water entering into the cassettes after construction and after the end of the period of insurance. As I've just said, Mr. Windsor will deal with this later, the judge made no finding that there was any substantial water ingress into the cassettes during the latter period. And my lord, that's important because it follows that the deterioration in the condition of the cassettes that occurred after the end of the period of insurance on the 15th of July 2017 was largely the playing out of what had gone before. It was the development or the deterioration of the physical damage that the judge found had occurred before the 15th of July 2017 as a result of water entering into the cassettes some 2 years earlier, between December 2014 and August 2015. And my lords, that takes me to the 4th and the last factual point I wanted to make. It concerns the impact of the ingress of water into the cassettes and the mechanisms by which damage would develop and spread. The impact of the ingress of water on the materials making up and encompassed within the cassettes would be progressive in a number of senses. The water would have an immediate impact on some items. For example, the mineral wool insulation within the cassettes, which would absorb water, compress or slump, which would reduce its thermal performance. See, in relation to that, the unchallenged evidence of Mr. Wellesley Smith in paragraph 7.5.1 of his report. For your note, it's Supplemental Bundle B, tab 40, page 459. See also Dr. Poole's report, paragraph 7.10, Supplemental Bundle D, tab 45, page 773. So an immediate impact on some items. The OSB 4, now my lords, that's the 22mm thick oriented strand board which formed the top of the cassettes. That would suffer from irrecoverable swelling, which would impact the strength of the OSB and require it to be replaced. There was no agreement between the experts as to precisely when that would occur.
Forgive me, that's the OSB on top of the upslope or the OSB on top of the gutter?
It's the
Because I think
both. It's the
same. It's the same.
It's the top deck of the cassettes. You have a cassette which is effective. I'm going to simplify it. So think of it as a rectangular.
I got in my mind for some reason there were two different kinds of OSB being used, but that
you're right about
it's
that.
The surface of the gutter and the surface of the upslope is the same OSB.
Yes, it's the top deck, and OSB 4. You're absolutely right. On the bottom is something called OSB 3.
Okay.
Different form of OSB, but on the top of the cassette, so below the Derbigum, it's OSB 4.
Thank you.
Water ingress is going to cause irrecoverable swelling of the board, which will impact its strength and require it to be replaced. As I said a moment ago, there was no agreement between the experts as to precisely when that would occur, although both wood science experts spoke of it taking place within months of wetting. What was common ground between the wood science experts is that irrecoverable swelling would occur before the onset of any decay. And the reference for that is the wood science experts joint statement, paragraph 3.2a, supplemental bundle D, tab 44, page 7.
I'm just going a little bit too fast. Give me that reference again.
Yes, the wood science experts joint causation
statement.
Report,
Yes.
sorry, joint report, paragraph 3.2a. And the bundle reference is supplemental bundle D, tab 44, page 750.
Thank you.
So that's irrecoverable swelling. So far as decay is concerned, as the judge explained in paragraph 156 of his judgment, wood decay is progressive unless arrested by drying out the wood to bring the moisture content below that which is required for decay to continue, which for timber, for the softwood timber, the wood science experts agreed was 20%. The agreed evidence of the wood science experts in their joint statement was that the effects of decay would tend to manifest earlier in OSB than in solid softwood. The precise rate at which OSB decays depends upon various unknowns, but the judge found in paragraph 140 of his judgment that it would be between 9 and 18 months. That's in relation to OSB. In relation to solid wood, so the timbers, the judge found in paragraph 141 of his judgment that it would take in the order of 18 months for decay, other than incipient decay, to manifest itself, during which time the moisture level had to be maintained at least 20%. So those, my lords, are various forms of impact.
And what constitutes solid softwood rather than OSB? Is it all the eaves and all the sides of the upslope?
Correct. It's the timbers making up the compartments. So not the top, not the top and the bottom.
But all the other timbers making up the compartment.
Yes.
Thank you.
Now, my lord, The point will be, I suspect, obvious from the timings that I've just given you, but if water entered into the cassettes between December 2014 and August 2015, then by the end of the period of insurance on the 15th of July 2017, so around 2 years later, there was ample time, not just for there to be damage to insulation, which, as I say, would happen almost immediately, but for there to be other forms of physical damage, including irrecoverable swelling, and for decay to either take place or to set in. That's simply the effects of the timings in terms of when the water got in and how these various forms of damage occur. My lords, in saying that, I want to be very clear about two things. The first is that the judge found in paragraphs 117 and 118 of his judgment that the entry of moisture into the cassettes during the period of insurance was a tangible physical change which constituted physical damage, so long, he said, as if the presence of the water, if left unattended, would affect the structural stability, strength or functionality, or the usable life or longevity of the cassettes during the period of insurance. And we say he was right to so find. But you should not think that the only form of damage that existed in the cassettes at the end of the period of insurance was the presence of water or moisture. Yes, there was some development and deterioration afterwards, at least until the end of the successful drying out works in 2018 and 19. But there was ample evidence that by the end of the period of insurance, there was damage other than the presence of water and wetted wood. Simply by way of example, the existence of the soft spots, which were found, as set out in the agreed chronology, between August 2016 and October 2017. Those soft spots, the wood science experts agreed, were indicative of water damage to OSB. The second thing that I want to be clear about is that you should not think, when you see references in insurer's skeleton argument in paragraphs 24 and 25, references to, quote, the presence of water or to the mere presence of water, that what we are concerned with here is water sitting or sloshing around inside the cassettes in some sort of harmless, amorphous way. What we're really talking about is wet, and often very wet, wood and other materials. And it's important in that context to note that the judge's finding in paragraph 117 of his judgment that the entry of moisture into the cassettes constituted a tangible physical change to the cassette and damage. And then to quote the judgment, as long as the presence of water, if left unattended, would affect the structural stability, strength or functionality or usable life of the cassettes during the period of insurance, that necessarily involves a finding that there was moisture in concentrations above the trigger levels required for irrecoverable swelling and for the initiation and the continuation of decay, and which would have those consequences if, as the judge said, it was not addressed. Now, my lords, I've been talking so far about, as it were, types of impact and severity. It's also important for you to understand that not only would water ingress have the harmful consequences that I've outlined, some of which would increase in severity over time, but the moisture that entered into the cassettes between December 2014 and August 2015 would inevitably spread within the cassettes. Water would travel through the wood by capillary action. There would also, and one sees this in the wood science experts' joint statement, paragraph 2.1c and d, it's supplemental bundle D, tab 44, page 747, there would also be redistribution of moisture by cyclical evaporation and condensation, which would allow decay and damage to spread within the cassettes. Now, my lords, I explained when I was making my first factual point that the cassettes were encapsulated. So once the water got into them, it was entrapped. Absent some intervention, such as the successful drying out operations that were ultimately carried out to the gutters in 2018 and 19, development of damage in the way I've described it, both in terms of severity and in terms of spread, was inevitable. Now, my lords, so far as that last point is concerned...
Sorry, can I just check? Are you saying it's that moisture would move around within an individual cassette, or are you saying that water would move from cassette to cassette?
The former. I'm not suggesting that water would move from cassette to cassette, but what I am suggesting is that it would move within the cassette from one compartment to the other. So, for example...
Is each cassette, as it were, should each cassette be, as it were, treated as a hermetically sealed unit next to another hermetically sealed unit? Or are there wood surfaces in contact underneath the waterproofing layer?
My understanding is that they are hermetically sealed units, yes. So moisture would not move from cassette to cassette, but what it would do is move within the cassette. Most obviously, if you have water getting into the gutter, it will move to the adjacent or the 2 or 3 adjacent compartments, upslope. But I'm not suggesting moving from cassette to cassette, but there would be that spread. Now, I made my point about inevitability. It's important for you to note that insurers have never pleaded that Sky failed to mitigate or failed to comply with its obligation under the policy to prevent or minimise further damage by unreasonably failing to take action earlier than it did.
Is there an express term under the policy, or is it just
Yes.
a duty to act as a prudent uninsured?
There is an express term in the policy to that effect. So there is no pleaded case that my clients failed to mitigate, failed to comply with the policy term to prevent or minimise further damage by failing to take remedial action any earlier than we did, such that the deterioration that took place after the end of the period of insurance should have been avoided. Now, although there's no pleaded case to that effect, there is the hint of a point if you look at insurer's skeleton paragraph 29.1, where insurers say that any further deterioration was not inevitable because it could have been arrested. But as far as that is concerned, we simply say that in the absence of a pleaded case, that if Sky had acted reasonably, any deterioration would have been prevented. So there is a break in the chain of causation. The point goes nowhere. There's no pleaded case to that effect. And indeed, insurers' point is actually, it's a much, much simpler one. Insurers simply say that they are not obliged to pay for any development or deterioration of damage after the end of the period of insurance on the 15th of July, in any circumstances, no matter how it occurred, even, and this must be their case, even development or deterioration that happened the very next day or the very next week. Now, my lords, that's what I wanted to say by way of, as it were, factual context, just to frame the grounds 1 to 3 issues. I want to turn now to the argument, and this is the argument concerning the hard stop. There are 2 arguments. The first is the subject of ground 1. The second is the subject of ground 3. And that there are these 2 arguments is reflected in paragraph 70 of the judge's judgment. If you want to turn it up, it's Core Bundle B, tab 15A, page 381. Ground 1 is the argument identified by the judge in A and B in that paragraph, first 3 lines. Ground 3 is the argument identified in paragraph 70C. Now, my lords, those two arguments may, of course, depending on the facts, have the same practical result, but they are different arguments. The first argument, ground one, concerns development or deterioration after the 15th of July 2017 that would happen inevitably during the necessary and or the reasonable period when the existence, the cause and the extent of the damage that had occurred during the period of insurance was being ascertained and or whilst remedial works to deal with that damage were being designed, approved, procured and ultimately implemented.
What one might call a reasonable mitigation period.
You might, yes. That would be a fair and shorter encapsulation of it. My lords, the important point is this. That argument assumes in insurers' favour that their primary obligation is strictly limited to indemnifying Sky in respect of the physical damage as it was at the end of the period of insurance. And I'll develop this in a moment, but it draws a distinction between the insurer's primary obligation to indemnify Sky in respect of that damage and the proper measure of their secondary obligation, namely to pay as damages the amount necessary to put Sky back in the position it would have been in before that damage occurred and to pay for the full cost of remediation as the policy requires. So that's the first argument, and I accept my Lord Justice Popplewell's pithy encapsulation of it. The second argument, ground three, as I said a moment ago, is different. Ground three poses a basic question of policy construction and of law concerning the meaning and effect of the phrase, quote, physical loss or damage occurring during the period of insurance. And that's the phrase that's used in the insuring clause in section 1 of the policy. And my lords, the question is this. When one has physical damage, which starts during the period of insurance, but which then continues and develops afterwards without the operation of any intervening cause, does the law regard the whole of that damage as occurring during the period of insurance, or only part of it? That's the fundamental question. We say that the answer is the former, and so there is cover for any development or deterioration of damage that starts during the period, but continues afterwards. And that, I'm sorry.
And just so that we're clear, the phrase development and deterioration, sometimes you use one or the other, sometimes you use both. But there may or may not be a distinction between, on the one hand, deterioration in existing damage in its severity or nature, and spread, that is to say, what you would call development.
That's precisely why I use both.
Which is your moisture.
Yes, that's precisely why I use both words, my lord. Yes, that's right. So, my lords, that's the basic question.
But
yes, I'm sorry.
We can use development as a shorthand for spread, can we?
Yes, I'm entirely happy to do that. Yes. That's the basic question. We say that the answer is the former, so that there is cover for any development or deterioration that starts during the period of damage, that starts during the period of insurance but continues afterwards. Now, what I've just said...
don't you have, just thinking on that exchange, there may be types of damage that are only seen after a certain time. It's not just a question of spread, is it? I mean, say, for example, rot. I mean, that might not be seen for a period of time, might not actually occur for a period of time, but is a new type of phenomenon, harm, damage, call it what you will, which only kicks in after a certain period. So it's not just a question of spread of something that was there before. I mean, there's spread and there's development in the sense of a new type of harm, damage.
Which I think is your deterioration.
It is. I mean, you're right that one has to distinguish between the discovery of damage that has already taken place.
Yeah, I was only querying the use of the word spread might not.
No, it doesn't cover everything. As I understand it, we may be concerned with two different things. Deterioration, which I think may capture what my lord's talking about, and development, which may be spread. And I'm only anxious just to, in my own mind, to recognise there is a distinction, because when one starts to think of analogies with floods and fires and so on,
Yes,
that it may be a distinction that matters and might matter for the law generally.
it might. Certainly when I was talking about deterioration, what I had in mind, in particular, would be decay. So you've got very wet wood, which, if left in that condition with moisture levels above the relevant trigger point, after a period of time, decay will set in and will then become worse and worse and worse over time. So when I was using the term deterioration, that was what I had in mind, although the same would, I suppose, be true in relation to irrecoverable swelling. It won't happen like that, but once your wood is left in that condition, over time, you will get irrecoverable swelling. When I used the word development, I suppose it could capture that too, but I had particularly in mind the spread of damage through the cassette. So it may be there's an overlap, but that is what I had in mind. What I did not have in mind was simply the discovery of damage that was, as it were, always there. I don't understand a point is taken against me in that regard. If there was damage by the end of the policy period, it wouldn't matter if it was found on that day or found 2 weeks later or 2 years later. The damage had actually taken place by the end of the policy period, no problem. Yes. Certainly as I understand Mr. Rigney's case. What we're really concerned with is development or deterioration of the type that I've described. So damage getting worse or damage spreading. And I put to you that the answer we say is that where you have that, where you have development and deterioration of damage that starts during the period, then the whole is covered. That proposition is consistent with what the Chancellor described only 2 weeks ago in this court as a first principle of losses occurring during insurance, namely, and this was what the Chancellor said, the loss is attributable to the policy year in which it first occurs. That was a decision in a case called Unipol-Psi versus Covea. Chancellor gave it the only substantive judgment. I think Lord Justice Popplewell was a member of the court, and we'll come back to look at that later. So the answer to the question that I put forward is entirely consistent with what the Chancellor said only 2 weeks ago. It's also consistent with the statements of principle that one sees in the authorities that were shown to the judge, which we submit he wrongly rejected or distinguished, and I'll come back to that later. So I've identified grounds 1 and grounds 3. I should say something briefly about ground 2, because you may think that it was a lost soul that had been forgotten about. Ground 2 it's addressed in our skeleton argument in paragraph 51. It is a criticism of 2 passages in the judge's judgment. Passages at paragraph 71 and 75. 71 is page 382 of the bundle. 75 starts on 383 and goes over the page. But it's a criticism of 2 passages in the judge's judgment, where the judge said, firstly, that the peril identified in the policy is simply loss and damage due to any negligence, breach of statutory duty, omission or default of Mace or its subcontractors. That's 71. And then in 75, the judge said that the intention of the parties, apparent from the terms of the construction contract, was that there would be cover for relevant loss or damage occurring after the end of the period of insurance under the policy that Mace was obliged to procure. Now, my lord, the criticism of the judge's reasoning in the first of those passages is accepted by insurers to be well-founded. You can see that in paragraph 18 and footnote 7 of insurers' responsive skeleton argument, core bundle A, tab 8, page 213. And that's accepted because the policy is an all risks policy. It's not limited to damage caused by some fault on the part of Mace. There are obvious causes of damage, natural perils being the most obvious, which would have nothing to do with any fault on the part of Mace at all. So that criticism of that first passage is accepted by insurers to be well-founded. Insurers don't deal with Sky's criticism of the judge's reasoning in the second passage, but for the reasons we've set out in writing, we would say that that criticism is well-founded also. But I accept that those criticisms and ground 2 are not by themselves going to justify a conclusion that the judge was wrong to say that there was a hard stop on the 15th of July 2017. So the criticism may well be valid, but I accept it's not going to get me home. And for those reasons, I don't propose to say anything more about ground 2 than I've said in writing already. I want to focus on grounds 1 and 3.
Just so I can clear my mind, well, if we're looking at the significance of things that happen or don't happen within a period of insurance, we may be concerned with the date at which an insured peril occurs, we may be concerned with the date at which damage occurs, and we may be concerned at the date at which damage is ascertained. And so far as insured perils under a contractor's all risk policy of this kind, is it right to say that the insured perils are all fortuities unless excluded?
Correct.
And if one looks at, which you may both say we're not, but if you look at when the insured peril occurs, it's what gives rise to the fortuity. So it would, on the judge's findings, be the defective design.
Well, and the ingress of water, yes. The defective design caused by the ingress of water.
Well, the ingress of water.
Sorry, the other way around, yes.
But it's in the same way as perils of the sea are a fortuitous ingress of water, the fortuity that one's looking at can be quite antecedent.
Yes, it can. It obviously has to operate on the subject matter of the insurance. I'm going to come back to this a little bit later. I mean, you're absolutely right to say that different types of insurance policy have different triggers. You may have a policy which is triggered by bodily injury occurring during the period of insurance. You may have a policy which is triggered by an event during the period of insurance. You may have a policy which is triggered by a peril or a casualty. Or you may have a policy which, whether you regard it as the insured peril or not, requires damage during the period of insurance. What I will say in due course is that actually running through all those cases is exactly the same principle. Namely, if your policy operates on I'm going to say losses occurring basis, but let's just say something occurring basis. If the something starts to occur during the policy period, then you have cover for the whole of it. I'll come and develop that later, but that's the submission. You're absolutely right that one can have different types of policy with different types of trigger. Can I then deal with ground 1? We make 2 criticisms of the judge's treatment of this issue. The first is that, having identified the argument in paragraph 70A and B of his judgment, and having identified it as a separate argument, the judge actually failed to address it, at least explicitly. You will have read this, but if you look over the succeeding paragraphs of the judgment, this section of the judgment, paragraphs 71 through to 78, the judge really dealt only with the second argument and with authorities that are relevant to that second argument, but which are irrelevant to the first. So the judge has, at least implicitly, rejected the first argument, but he's given no reasons for its rejection. But I accept, of course, that that criticism will get me nowhere if you think that my point is a bad one. So I focus on the second criticism. The second criticism is that the judge was wrong to reject the argument, as he implicitly did. Now, the reasons why we say the judge has gone wrong, they're dealt with in our written submissions at paragraph 34 to 39, which I obviously won't just repeat, but I want to make, if I may, 4 points. The first is simply to note that the points we made in paragraphs 34 and 35 of our skeleton, all matters of basic principle, are common ground. And I say they're common ground because Mr. Rigney's skeleton, paragraph 27, accepts that they are correct. And so it is common ground, first of all, the policy is a contract of indemnity, under the terms of which insurers agreed to hold Sky harmless in respect of physical loss or damage to insured property occurring within the period of insurance. It's common ground that insurers will be in breach and liable in unliquidated damages for failing to prevent Sky from suffering from that harm if it occurs. It's common ground that so far as the measure of damages is concerned...
I know we've got a transcript, so I hope we're getting a transcript, but you slipped the word prevent in there. Can we just run that through again?
Yes. The point that I was putting as common ground and also correct as a matter of principle is that insurers will be in breach of contract and liable in unliquidated damages for failing to prevent Sky from suffering the relevant insured harm.
Yeah,
it's the
principle
phantom.
which is not intuitive to non-insurance lawyers, that the insurers are already in breach of contract the moment the casualty occurs,
Correct.
having failed to prevent it happening.
Correct, but I think
But that is the principle, and that's the reason you can't, for example, get damages for insurers failing to pay, because you can't get damages for non-payment of damages.
Well, now of course you can.
Now you can, but
the law has changed.
You couldn't as a matter of common law principles.
Yes, and the authority for that is well known. It's the decision of the House of Lords and the Fanti.
Yes.
Quite some time ago. So that was one aspect of common ground. The other aspect of common ground is that so far as the measure of damages is concerned, subject to the policy terms, Sky is entitled to damages to put itself in the position it would have been in if the relevant physical damage and the insurer's breach had not occurred. So in the present case, to put Sky back in the position it would have been in with an undamaged roof. Common ground, well-established principle. And then thirdly, and this is just focusing on the policy, under the basis of settlement clause in the policy, it's core bundle C, tab 25A, page 770, insurers are obliged to pay for, quote, the full cost of repairing, reinstating, or replacing the property damaged. Now, taking that point together with the point I just made, it means reinstating or restoring the roof to the condition it was in before the relevant damage occurred. Now, I've already said that the authority for the first of those propositions is Lord Gough's speech in the Fanti. The second, concerning the measure of damages, probably the best authority is the decision of Sir Peter Webster in a case called Callaghan and Dominion. Now, it's in your authorities bundle, it's tab 17, pages 286 to 291. I will not take you to that in the interests of time, but the authority is useful because it draws a distinction between what the judge referred to as insurer's primary obligation to indemnify and insurer's secondary liability to pay damages to put the insured in its pre-loss position, and also the quantification of that liability.
I'm not sure I understand what the distinction is. Of course, we talk about an obligation to indemnify, but actually what we know we mean is a liability in damages for having failed to prevent the assured from suffering the harm in the first place. It's a contractual damages claim.
It is a contractual damage.
So what is the distinction between, on the one hand, the liability to indemnify, and on the other hand, the obligation to pay damages?
Well, the obligation to pay damages is the secondary obligation. This is going back to ordinary contract law. This is the secondary obligation that arises from the breach in preventing the harm from taking place at all. But it's really a question of the measure of damages and the quantification that's important. And that's a point that Sir Peter Webster drew out quite nicely in that case.
We might need to look at it because I entirely understand the way your submissions are structured, but it may be that the focus of the argument is on the interplay between the first and second of them, because it may be said that the contractual obligation is to hold you harmless from not just any damage, but the insured damage.
Yes.
And that the failure to do that gives rise to a claim in damages, which are damages for having failed to prevent you suffering the insured damage, not all damage. And if we're drawing a distinction at stage 2 between the original obligation and the damages claim, that may be where the fault line lies between you. I may be wrong, but
My Lord, it may be. I quite accept that the obligation to indemnify is only, as your Lordship says, in relation to insured damage. When one comes to the measure of damages and the question of, well, what has to be done to put Sky back in the position it would have been in had the relevant damage not occurred, and how much does it cost to do that, there is, we would say, a distinction. And I'm going to explain why in a moment, and if we need to look at Callaghan, we can do so.
all right.
But the point, my Lord, is this. Yes, primary obligation to indemnify Sky in respect of physical damage that occurred during the period of insurance.
No, primary obligation to prevent it happening.
Yes. Yes.
Is that right?
To prevent it happening.
Yes.
Secondary obligation and the measure of damages, one has to ask the question, well, what work is required and what cost has to be incurred in order to put Sky in the position it would have been in if the relevant physical damage had not occurred. Now that, we would say, is an entirely factual matter. It involves considering, as a practical matter, what has to be done, how and when it can be done, and the costs that are involved in putting Sky back in the position it would have been in before the relevant damage, the insured damage, to use my Lord Justice Popplewell's phrase, occurred. We say that's an entirely factual, practical question.
And for these purposes, the damage, which you say the insurers were in breach of their primary obligation by having failed to prevent happening, is all damage prior to the end of the period of insurance.
Yes, it stops. It looks at the position only as at the 15th of July 2017. For the purposes of this ground one, yes, that assumption is made in insurers' favour. So your starting point is the insurers have failed to prevent Sky from suffering that damage. Sky is entitled to damages to put it back in the position it would have been in had that damage not occurred. And the question is then, how do you measure that? And that, we say, raises a factual and indeed a practical matter of what has to be done, how and when it can be done, and how much will it cost. Now, so far as that is concerned...
Why is not the measure the cost of repairing the damage as it existed at the end of the period of indemnity?
It is exactly that. But in order to answer that question, one has to ask necessarily, well, what work has to be done, how and when can it be done, and what will the cost be involved? That's just how you measure the damages that are payable.
Well, I can quite see that. I'm just trying to tease out sort of where the difference is between the parties. I can quite see that it may well be the case that the costs of repairing the damage as it exists at the end of the period of indemnity is the same as the cost of repairing of the repairs which are undertaken later when it has deteriorated. And that's what the judge found in relation to the position between 2017 and the end of the drying out works in 2018/2019. But if that isn't the case, well then there's no problem. But if that isn't the case, and there is some deterioration or spread, which makes it necessarily more expensive to do that which you are going to do at the end of the reasonable mitigation period than it would have been to have done it at the end of the period of indemnity. Why is that the cost of remedying what you say the insurers have failed to do in preventing the damage which is the damage which occurs at the end of the insurance period?
I'm not sure, my lord, as if there's an awful lot between us. Can I try and deal with this just as a practical matter first to identify what needs to be done and how, and then come back to your lordship's question? Because as I say, I think actually we may be talking about the same thing. Your lordship used the word reasonable mitigation period. If your lordship meant by that the reasonable period that will be required to carry out the works, then I'm not sure there's, as I say, much between us. But my lord, let me put it this way. As you'll have gathered from the judgment, the roof of Sky Central is a large, complex, integrated structure. The damage at the end of the period of insurance, even on the judge's findings, was extensive, with 383 of the 428 cassettes on the main part of the roof requiring repair. And the judge also found, he recorded, that Sky Central has been occupied since August 2016 by between 3,500 and 4,000 workers. So any remedial works would have to be carried out to the roof of an occupied building. Now, as one would expect, and as one sees from the end of the judge's judgment, those facts give rise to a whole host of issues: safely accessing the roof, carrying out repairs, including cutting holes in the roof whilst avoiding further water ingress, carrying out hot works on the Derbigum, and doing all of that safely whilst people are working underneath. And without wishing to be facetious, sorting out the problem is not just a question of sending 2 or 3 workers up with a hammer and a chisel. In terms of timing, insurer's own remedial expert, this is Mr. Jessup, his evidence was this, and I'll give you the references. He said, even if surveying the damage and devising a scheme had commenced in late 2016, so that's before the end of the period of insurance, he said that the earliest Sky could have carried out a remedial scheme would be in 2018 and 2019. That was his second report, paragraph 4.28. It's supplemental bundle E, tab 60, page 909. And he was also asked about that in cross-examination in a passage you will see in supplemental bundle E, tab 76A, at page 1120. So that's just in terms of when any remedial scheme could start. In terms of how long it would take to complete, his evidence was that it wouldn't have been completed before spring 2021 at the earliest. And the reference to that is his Mr. Jessup's cross-examination. It was supplemental bundle E, tab 76D, page 1125, and the tab has an extract from his cross-examination. It's page 9, lines 21 to 23. So that's how long, bearing in mind the nature of what we're dealing with here, it would take to get a remedial scheme to remedy the damage that had occurred by the end of the period of insurance up and running and to complete it. Now, during that period, but subject to a qualification I'm going to mention in a second, but during that period, Mr. Jessup accepted in cross-examination that further deterioration caused by the moisture trapped within the cassettes was inevitably going to occur. That was his evidence. Again, supplemental bundle E, tab 76D, page 1125. Mr. Jessup's qualification was that, well, that's subject to the cassettes not having adequate ventilation and the risk not being managed by ventilation and by drying. But in relation to that, I'd say two things. First of all, as I've already explained, insurers have pleaded no case that Sky failed to mitigate its loss or that Sky acted unreasonably in failing to act earlier than it did and to dry out the cassettes. But secondly, even if that sort of point were open to insurers, which it's not, the fact that deterioration might have been managed and minimised by carrying out ventilation and drying, it's actually no answer to the point of principle. It doesn't support insurers' case that there can be no recovery for deterioration that takes place at any time after the end of the period in any circumstances. Now, so far as that second point is concerned, there is a factual description in Dr. Poole's report. It's paragraph 6.11, supplemental bundle D, tab 45, pages 770 to 771. There's a factual description of the methodology that was developed for the drying out works that were conducted in 2018 and 19. And if I can just break it down, this was the plan. Holes were to be cut into the compartments of the cassette and mineral wool insulation removed. Vent housings were then...
What insulation? Minimal?
Mineral.
Mineral.
There's mineral wool insulation within the cassette. So your starting point, you cut a hole...
That's why I thought you said minimal. Mineral, thank you.
You cut a hole into the compartment. You remove the mineral wool insulation.
Yes.
A vent housing is then installed over each hole. Dry air is then blown through the cassettes until the moisture content is below a specific figure. And what was then intended to happen was that the vent housings were removed, fresh insulation would be installed, the holes would be repaired, and new Derbigum waterproofing would be laid. That was the plan for the works in 2018-19. As it happens, the vent housings have been left in place, but that was the plan. That's how you go about drying out the cassettes. And actually, I've referred to Dr. Poole's report. You could find a similar description in Mr. Jessop's report, where he describes what he terms a repair type 1 scheme.
So why are we getting into the detail of the repair scheme? Sorry, I've lost the thread of where you're headed with this.
Well,
Other than the scheme, the remedial scheme takes time. Why are we getting into the detail of what the remedial scheme is?
We're getting into the detail of it for two reasons. First of all, Mr. Jessop has accepted that absent drying out or ventilation, you're going to get some deterioration. Yeah. I've just told you the process that would be involved to carry out a drying out exercise. And the point I was about to make is that that doesn't happen instantly. It took, as it happened, about a year between June 2018 and August 2019 for that process to be carried out during those years. So even if you were going to deal with it this way, you've inevitably got a period of time where things are going to get worse. So it's not really an answer to the point, well, there has to be a hard stop as at the 15th of July 2017. Doesn't answer the point. I mean,
is it any more than there is bound to be a period of reasonable mitigation before you can remedy the damage that exists at the end of the period of insurance? Is that? I mean, that's the basic point, is it?
My lord, that is the basic point. But my learned friend's case is that even though during that period there will be inevitably development and deterioration,
yes,
nonetheless, the insurers don't have to deal with it.
Yes.
Even though it would inevitably take that long, and in order to put the roof back in the position it was before the relevant damage had occurred, you'd have to deal with that.
Yes.
Not their fault.
In this case, is because that's what the contract says. That's what we've got to decide.
Well, it is, but with respect, insurers confuse two things. They confuse their primary liability to hold Sky harmless against physical damage occurring during the period of insurance, with their obligation to pay damages for breach of that obligation and the proper measure of those damages, which is to meet the financial costs of putting Sky back in the position.
Well, the key is in the first 5 words of paragraph 35 of your skeleton argument, isn't it? And that's really what's between you. The words being subject to the policy terms.
Yes.
And that's what this is all about.
Well, and if one looks at the policy term, we would say it was part of the full cost of remediation. Let's test it this way. I've just explained a moment ago what drying out works would involve. And the first step in that is actually cutting a hole into the top of a cassette to install a vent housing to allow you to pump air in. And then once you've done that, once you've dried out the cassette, you then repair the hole. Now, the cutting of a hole in a cassette involves physical damage, inevitably. It is what is referred to as access damage. It's damage that is necessary for the purposes of carrying out repairs, and it's part and parcel of remediation. So if drying out works had been carried out after the 15th of July 2017 to deal with the damage that had already occurred by that date, then in order to do that work, in order to restore the roof, would have been necessary to cut holes in the tops of the cassettes, to blow air through, and then at the end of the process to repair those holes and to relay the Durbigum. Now, I raise that point because insurers plead that they're not liable for access damage that's caused to address property that's defective. And we accept that. That's the effect of the DE5 exclusion. But insurers do not plead, and I don't understand them to say that access damage that's necessary to address property that's not just defective but damaged is irrecoverable. And we would say it's plainly not. It forms part and parcel of the necessary process of remediating that damage which has already occurred. And it's actually part and parcel of the insurer's own 2018-19 scheme. But the acceptance of that demonstrates 2 points. It demonstrates that the supposed principle that there can be no recovery for the costs of repairing any damage that occurs after the 15th of July in any circumstances, it can't stand, because that access damage will need to be repaired, and that access damage takes place after the 15th of July.
Is that not where the doctrine of mitigation comes in? Which is something else we may have to factor into. You don't, as I understand it, as part of your argument, say, because you can't do anything for a period of years, effectively, after the end of the period of insurance, to actually put in place remediation works, that doing nothing is reasonable mitigation. And this comes then within the second limb of the mitigation principle, that if you do something, i.e. nothing, in reasonable mitigation of damage, you can recover for that, even if it increases the level of damage. But in relation to what you're now talking about, active steps to investigate, then they're all part of mitigation loss, aren't they, to prevent more serious damage, presumably in the same way as decanting costs are. I mean, that's mitigation loss, isn't it?
Well, quite, but it then does raise this question. What is the difference in principle between addressing access damage in the way that I've just described and taking a period in order to design and carry out remedial works, during which period further damage is going to take place? Both are a necessary part and parcel of a sensible remediation process. You don't just literally on the 16th of July rush onto the roof. You can't do that. It takes time to plan a proper remedial scheme. Damage is going to occur, further damage will occur during that period of time. Is that very different from remedying access damage that you have to cause in order to repair the roof. We would say it's not. They are both part and parcel of a remedial process. One involves, yes, deliberately causing damage and then having to repair it at the end of the day. The second involves taking time to plan a process during which further damage you know will occur, but you have to deal with that too.
I understand. You have the remedial process for drying out, and as I understand it, what you're saying is whilst you're preparing that and undertaking it, there'll be further deterioration, presumably primarily decay, swelling, decay.
Yeah, yes, one would imagine that most irrecoverable swelling would have taken place by then, but certainly decay, yes.
So what I'm trying to understand at the moment is, well, what does that mean in practical terms? Does that mean that the remedial process will be undertaken, but then there would have to be a further remedial process to deal with the further deterioration?
No, I mean, the point I'm making is that both would have to be dealt with as part of the same process. So you'd have a single remedial process which would encompass dealing with the damage that had occurred by the end of the period of insurance, and that for any further damage that had occurred during the period when you were actually formulating your remedial scheme. And part of the process of putting Sky back in the position it would have been in if the original insured damage hadn't taken place. Part of that process inevitably involves dealing both with your access damage but also the further damage that happens while you're plotting out your remedial scheme. Both are part and parcel of the full costs of remediating the damage.
I mean, as I understand it, you say that let's assume in a very ideal and perhaps slightly unrealistic world that the problem had been appreciated by the end of the period of insurance, and cassette 1 was dealt with the day after the end of the period of insurance. At that stage, you would know precisely what the damage was to that cassette at the end of the period of insurance, and your remedy would only have to address that damage.
Yes.
But by the time you'd worked your way around to cassette 484, let's assume, it might well be that cassette 484 had suffered a further deterioration. For example, rotter might have set in. You say, well, it takes time. Remedying the rot, i.e. perhaps replacing a section of wood internally or spraying with fungicide or whatever, would be covered. And insurers say not, because that rot, we know, only set in at cassette 484 during the period it was taking you to remedy cassette 1 to cassette 483. Have I got the sort of parameters of the dispute between you?
Well, my lord, yes, you have. And the short point is you can't, when you're dealing with a property of this sort, you can't simply magic a scheme in place on the day after.
No, well, I did
the
say
end
it was
of the
unrealistic.
policy period.
I said it was unrealistic, but I was doing it to test, just
Yes.
to understand the different parameters of the argument.
But you have it exactly right. And indeed, just going back to reasonable mitigation, it would be inconsistent with our duty to mitigate and to minimise loss for Sky to proceed with an ill-thought-out programme of repairs just because that could be done very quickly. I mean, no sensible property owner and no sensible contractor would do that. So part and parcel of the process of mitigating the damage would be to properly formulate what is required. And if what is required involves access damage, so causing further damage and repairing it in order to remediate, also covered, it's part and parcel of remediation. If part of what is required is taking time to formulate a plan, then any deterioration during that period is covered as well. And it is,
as indeed you say, would be any further deterioration in some of the units caused during the period of time of actually getting round to those units.
Yeah, exactly. I mean, maybe
To some extent, they're all dependent upon the issue of what is the damage. Because if the damage is that the cassette has suffered an ingress of moisture, which puts it in a position whereby it will thereafter suffer progressive deterioration, then by definition the damage was caused at the point of the ingress of the moisture.
Well, that is undoubtedly right. I'm trying to avoid trespassing onto other grounds of appeal, both my own ground 3 and insurer's ground 1 at the moment. But yes, to some extent, you're obviously right about that. But Mace has
it renders this redundant, doesn't it?
Well, it may or may not do. I think insurers would say, well, if all that is required is literally to remedy the property, as it was, as at the 15th of July, then the scope of the works are reduced. I mean, it might be you have to look at one compartment, not another compartment, because the damage is spread over the intervening period. So maybe it goes towards the costs that are involved.
So you know that the moisture is there. You know it's going to spread. I think, as my Lord has said, it's really a question of then becomes a matter of mitigation.
But it may be a question of what
happens in the meantime.
But it may be a question of exactly what work has to be carried out. I mean, if you had a cassette where you had water in it, in the wood, but at that stage all that was required was a drying out process, then that would involve obviously some cost. If by the time you get to it, you've actually not got, you don't just have that, but you've got wood which has rotted and has to be replaced, then the cost would be increased. So it may be relevant for that reason. But my lords, I mean, I put the arguments as part and parcel of the remediation process, both in terms of access damage and repairing any inevitable deterioration during planning. You could just as easily put it as part and parcel of a reasonable mitigation process. And indeed, if one looks at my learned friend Mr. Reed's skeleton argument, it's paragraphs 48 and 49, he puts it in very much that way, and no doubt he'll develop this if he wants to. Can I just, coming to the end of my treatment of ground 1, I just want to deal with a couple of points that have been raised by insurers. And they've been raised by insurers in...
So when you say you're coming to the end of ground 1, do I assume we're actually going to look at some authorities at some point?
Well, we are in relation to ground 3.
Right.
Ground 3, we need to look at authorities. Ground 1, as I say, it's an argument which is really based on practicalities, on the measure of damages, on the work that's required to remediate the property damage that had occurred by the 15th of July. It doesn't require me, for the purposes of ground 1, to look at many authorities. Ground 3 certainly does, but it's a different question. Just to pick up some points that insurers made, and they're responding in paragraphs 29.2 and 29.3 of their skeleton argument to some points that we have made in paragraph 38 of our own skeleton argument. And with respect to the insurers, they have mischaracterised Sky's case. It is undoubtedly correct, as we submitted in paragraph 38.1 of our skeleton argument, that the deterioration and or the development of damage after the 15th of July did not arise from some new happening after the end of the period of insurance. Say, for example, some further substantial ingress of water. As I mentioned earlier, the judge made no finding that there was any substantial ingress of water into cassettes after the end of the period of insurance. Secondly, and again with respect to insurers, it is also undoubtedly correct to say that the deterioration and development that took place flowed from the original physical damage that had taken place during the period of insurance, whether that be the moisture within the cassettes causing the initiation of decay, or decay that was in progress and got worse. And there is no confusion on our part between Mace's and insurers' breaches of their respective obligations. I agree with Mr. Rigney that insurers' promise was that physical damage would not occur during the period of insurance, and insurers agreed to hold Sky harmless against that eventuality. Where Mr. Rigney and I part company is that, in our submission, insurers failed to grapple with the measure of damages and the work that was required to be done.
Can I just explore how far you say that the measure of damages is subject to the policy terms, as you put it in paragraph 35? Suppose that the policy said that the insuring clause is for damages occurring during the period of insurance. It then went on, and in no circumstances shall the insurers be liable for damage which occurs thereafter, whether by way of development, deterioration, or otherwise.
Yes.
Now, the way you're putting the argument at the moment, I think, is that that would be irrelevant. This would still be recoverable because they'd failed to hold you harmless from suffering the damage during the period of insurance, and this was simply the consequence of their having done so. Is that right?
Well, if you had a term of that sort, then the answer might be different, because the parties would have contractually agreed in those circumstances that the position would be different. I mean, it's an argument that arises in the context of ground 3, certainly.
No, I'm putting it to you that it arises in the context of ground 1, which, as formulated by you, or in any way, I think as it's going to be put against you, that the measure of damages is itself circumscribed by the terms of the policy. And if the terms of the policy are such that this is not the damage the insurers have agreed to indemnify you for, then just because it's a damages claim doesn't mean that you ignore that fact. Well, that's what I'm testing.
If the terms of the policy close down the argument that I've just made,
yes,
then they would obviously take precedence.
Right. Well, then what is the difference between, on the one hand, a policy which says we shall be liable for damage occurring during the period of insurance, and a policy which says we shall be liable for damage occurring during the period of insurance, brackets, for the avoidance of doubt, we shall not be liable for damage occurring at another time?
Well, you don't have the explicit language that would be necessary to deal with the argument that I've advanced. What we have here in this policy is a basis of settlement clause, which provides that in settlement of claims, an indemnity will be provided on the basis of the full cost of repairing, reinstatement, or replacing property lost or damaged. Now, that must mean putting Sky back in the position it would have been in with an undamaged roof. If, in order to do that, you need to deal with access damage, or you need to deal with any further damage that inevitably occurs whilst you're formulating and carrying out your remediation, then that, we would say, is part of the full cost of repairing, reinstating the property.
Only damage which inevitably occurs.
Yes, I made it clear, I think, at a much earlier stage. If one's talking about damage which is caused by, if there's some break in the chain of causation or something of that sort, whether it be some new happening or a failure to mitigate, then that would be different. But where you're not talking about that, and on the contrary, you're talking about taking time reasonably and sensibly to formulate a scheme, necessitating that, or rather...
So it's damage which in fact occurs in the ordinary course.
Yes.
I don't like the word inevitably, but you're saying the cut-off is only a break in the chain of causation or a failure
Correct.
to mitigate.
Yes, breaking the chain of causation.
So it's something, damage which in the ordinary course of events occurred is what you're saying.
Yes.
Is caught, only cut off by those two possibilities.
Yes, it is. And as I say, test it. You can test it by looking at access damage. Now that is damage that takes place after the 15th of July. And Mr. Rigney has to explain, well, how is that covered if there is a complete hard stop? His answer...
And if his answer is well, that's expense in reasonable mitigation of damage. What's wrong with that?
To which I would say, what's the difference in principle between that and damage that occurs during the, whether it's 1 month or 3 month period, when you're sensibly and properly putting in place a mitigation, a scheme to remediate the damage? There's no difference in principle.
And that argument is essentially seeking to recover this as mitigation loss, which as it happens has increased the damage, rather than by reference to any principle in the FANTI. Juridically, it's a quite separate basis of argument, isn't it? And the reason I'm anxious to tease that out, if I'm right, I may not be, I'm just asking about it, is that I'm not myself aware of any case in which failure to do something, which might be characterised as a reasonable mitigation because it's reasonable not to do anything, has been treated as coming in within the second limb of mitigation loss, i.e. something which has actually increased the damage, but you can recover it because it's increased the damage.
Well, my lord, it's very difficult, because if instead of taking time to formulate a sensible remedial scheme, a party just rushed in and said, well, we have to avoid any further damage, we're going to rush in straight away, that would likely be inefficient and probably waste money at the end of the day. So it wouldn't be done properly. So taking the time to prepare a sensible remediation scheme is itself reasonable mitigation. Now, I quite accept that what we're not dealing with here is, as it were, an additional mitigation cost. So there is that difference. But actually, in substance, putting together a reasonable remedial scheme must itself be a mitigation expense. Why should that not embrace the fact that it's going to take a month or 6 weeks or whatever to do it, and during that time there'll be a bit more damage you've got to deal with?
Well, I understand that the argument can be put in that way. I was simply putting to you two aspects of that. One is, I think it is a very different argument from that which is based on the FANTI. But you may say it's the same because mitigation is all about causation, which I think...
Yes. Sometimes
Mr. Justice Robert Goff had said in the Elena D'Amico, although it's not...
Right.
That may not be so.
No.
And because it may be at least extending the boundaries of the second limb of mitigation loss beyond anything that's previously been identified. There are plenty of cases where someone has taken an active step to mitigate, which, as it's turned out, although reasonable, has increased the loss, and then the principle applies, well, you get the increased loss. That's the corollary of the obligation to act reasonably, which, if it reduces the loss, reduces the liability. But I'm not aware of any case in which doing nothing has itself been treated as a reasonable failure to mitigate so as to justify recoverable of additional damage caused by doing nothing.
Well,
I'm just teasing out the juridical bases for your argument. I quite understand your basic point, which is it would be jolly unfair if you couldn't recover this, because what else are you to do? Because you can't rush in. You've got to take time to take remedial steps, and damage will inevitably deteriorate, you say, in the meantime. But I'm just trying to tease out the different juridical bases on which you're saying you're entitled to recover this.
Well, I understand that. I don't want to offence my lordship, but can I just pick up the doing nothing comment?
Yes.
Because actually you're not doing nothing. You're taking the time that's required to plan a sensible remedial scheme.
Yes.
So you're actually doing something. You're planning.
Yes.
And because you take the time,
You're
further damage will be caused. So I don't quite accept it's a doing nothing situation. My lord,
difficulty though with the argument that access damage proves the point, because access damage is part and parcel of the repair, and there's an express entitlement to recover the cost of repair. So that comes under the basis of settlement clause.
Well, yes, access damage is part and parcel of the repair. We would say taking time to prepare, or preparing a proper remedial scheme, is also part and parcel of the repair. And if, as a result of doing that...
But whereas one can see the access damage, I'd have thought, the cost of that plainly comes under the basis of settlement clause, I'm not sure you can say that the damage caused by continuing deterioration in the meantime comes within that clause.
What I'm really using excess damage to do is to try and test the principle of whether it is right that in no circumstances can insurers be required to repair damage that occurs after the 15th of July. Now, excess damage means that that principle cannot be right because they would have to deal with that. So that's the principal reason I'm using excess damage.
It doesn't work if it's a cost of repair.
Well, but that, if I may, and I don't want offence, but we are debating what is a cost of repair and what is not. And I would say, as I've said, that a cost of repair is also preparing a remedial scheme. And if it takes 6 weeks or whatever, then that's
Well, I think you say implementing that remedial scheme as well.
Well, yes, although actually preparing a remedial scheme for a building like this is quite something itself.
Yeah.
But my lords, I'm conscious of the time.
Yes,
Can I move on?
Yes,
And I'm going to move, if I may, to ground 3.
which is the damage occurs when it first occurs,
Yeah, yes. And,
as a matter of law.
as a matter of law or policy construction, maybe actually a policy construction issue. The point is straightforward. You have an insuring clause in the policy. In section 1, it's core bundle C, tab 25A, page 770. It provides an indemnity for physical damage to property insured occurring during the period of insurance. And that clause poses this question. How does the requirement that physical damage should, quotes, occur during the period of insurance apply to damage which starts during the period of insurance but which continues and develops afterwards? So there are, I suppose, two possibilities. Either, if the damage starts during the period of insurance but develops and deteriorates thereafter, the policy extends to the whole being regarded as having occurred during the policy period. The alternative is that if the damage starts during the period of insurance but develops and deteriorates thereafter, you have to parse the damage to identify the particular extent of the damage at a particular point in time, with the policy only responding to the precise state of affairs as at the end of the period of insurance. So those are the two possibilities. We say that the former is generally correct, and I say generally because, of course, I accept that it would be possible for a policy to expressly provide that that was not so. But even if a policy could do that, this one doesn't. So that's the question, the two possible answers and our preferred solution. We make 3 submissions. The first, and I touched on this earlier, and I am going to show you some authorities, is that the answer I've just given is consistent with what the Chancellor said 2 weeks ago as a first principle of losses occurring during insurance, namely that a loss is attributable to the policy year in which it first occurs. And as I will show you, that proposition is not unique to policies such as this one, which contain a physical damage trigger. It also applies to policies that contain a bodily injury trigger, or a trigger that references a peril or a casualty or an event. And that first principle, to use the Chancellor's words, is reflected in some of the statements of principle that we will see reflected in the authorities that the judge was shown. So that's the first, as it were, overarching submission. The second is that if I'm right about that, it means that insurance law approaches developing injury or damage in the same way as that topic is treated under the general law. Now, consistency or coherency is perhaps always desirable in the law, but it's particularly important in this context because in relation to liability insurance, and liability insurance is itself also written on a losses occurring during basis, but in relation to liability insurance, there is an interface between insurance law and the terms of the insurance policy and other areas of the law, most obviously tort law. So there is an importance in coherence and consistency. The third point, third overarching submission, is that my answer makes commercial sense and it avoids some very obvious difficulties if the position is otherwise. It means that where successive time policies are placed, each for an annual period, on a losses occurring during basis, liability for the whole of the same injury or damage will be allocated to 1 year or another. It avoids problems of insurability that are inherent in the proposition that one insurer, a second insurer, might be liable for the continuance of damage or for the consequences of a peril or an event that is already ongoing at the time that second insurer comes on risk. So those are the three overarching submissions. I'm going to develop them, but I want to get 3 points out of the way right at the start. First of all, I recognise that the stated period of time is fundamental to the operation of a time policy. That was a point that was made by Lord Justice Hobhouse in Municipal Mutual, which we're going to look at later. It's been repeated in subsequent authorities. I entirely accept it. Second thing I wanted to get out of the way is that I also accept that the insuring clause in section 1 of the policy provides for a physical damage trigger. So there must be some physical damage caused by an insured peril during the period of insurance before the insurance responds. So I do not say that this policy is triggered by something that happens even if there's no physical damage at all during the period of insurance. I do not say that the policy responds if all that has occurred is a risk of damage, however imminent. Again, Lord Justice Hobhouse, this time I think in the Nukila, said that imminence of loss and damage is not the same as damage. I accept that. Third point, I've spoken now a number of times about damage that develops or perhaps continues over time. It's very important I explain exactly what I mean and what I don't. I can explain what I mean by reference to an example that Mr. Rigney used in his closing submissions at the trial when he was addressing this topic. Now, Mr. Rigney's example, it's not in the bundles, but I can read it out, it's very short. He said this: suppose, Mr. Rigney said, you have a leak in a water main near a house, and suppose it's a relatively minor one, the consequence of which is that you get a little bit of dampness in one corner of the kitchen. That takes place within the period of insurance. Suppose then that there is a catastrophic failure of that water main and the entire ground floor of the house is flooded, but that takes place after the expiry of the period of insurance. And then Mr. Rigney went on to say, on the claimant's case, they recover the whole lot, but on our case, they can only recover in respect of the modest damage to the corner of the kitchen. Now, that was the example or the analogy that Mr. Rigney drew. It was inapposite, as Miss Day, who was representing Sky at the time, pointed out, because what Mr. Rigney describes is plainly something that involves two separate instances of the operation of an insured peril, each causing different damage. You have the initial relatively minor leak in the water main, which leads to dampness in the corner of the kitchen. And then there's a different event, which is the catastrophic failure of the water main, which leads to flooding of the whole ground floor of the house, which happens after the end of the period of insurance.
But if you amend his example so that you only have a single catastrophic event, you've got a flood as a result of a dam breaking, and the flood gradually rises. During the period of insurance, it's only got far enough to cause a little bit of damp in the kitchen, but it continues to rise and it then floods the kitchen. Well, so take out the separate cause,
Well, that was broadly, my lord, the point I was going to make. The analogy as put isn't appropriate. If you wanted to, as it were, tweak it...
Right.
To
Take
make it
the tweaked analogy. You say that is covered.
Yes, I mean, the tweaked analogy would be, assume the minor water leak in the main is resolved. There's no more water ingress. But before anyone has had time to address it, the dampness in the corner of the kitchen, which at the end of the period of insurance involves just staining to the skirting boards, then causes the skirting boards to decay, or assume the water travels up the adjacent wall through capillary action. So no, as it were, separate new incident. All you have, before anybody's been able to deal with what's occurred, is damage deteriorating or spreading in that way. But the point I make is that when I'm talking about damage continuing or developing, I'm not talking about Mr. Rigney's example. I'm talking about what I've just described. We're going to come back to Municipal, Mutual and WASA in a few moments, but I want to make clear right now that although we rely upon certain statements of principle in those cases, neither of those cases was, as a matter of fact, concerned with continuous or developing damage of the type I've described. Municipal Mutual, and we'll see this, concerned 2 dragline elevators which were damaged by what Lord Justice Hobhouse described as a whole succession of individual acts of pilferage and vandalism carried out by a number of individuals, probably acting independently of one another over a 3-year period. WASA and Lexington, as Lord Mance explains, was concerned with contamination at 58 sites, 35 within the US, 23 outside the US, at which either an aluminium company, Alcoa, or its subsidiary had generated and disposed of waste over the course of decades. Again, you're dealing with separate incidences of damage. And there is, in my submission, a very obvious distinction, as a matter of fact, between those cases and this one. Can I then deal with my first overarching submission? That's the principle, losses occurring during. And as I've said, the submission is that where an insurer...
I'm sorry to keep holding you up, but I just want to see the scope of the argument. When you're talking about development, as opposed to deterioration in the context of the current facts, you're talking about spread, but not spread in terms of the continuing operation of the insured peril, such as a flood continuing to affect a building. You're simply talking about development of the damage itself by way of spread into...
I am, and that's exactly why, when I gave you the tweaked analogy, I said, assume the water leak has stopped.
So when you look at the principle, as it were, of the damage all being treated as occurring when the damage is first suffered, is that limited to deterioration in the way we've been describing, or is it a more general principle of continuing operation of the insured peril?
But it may depend on your type of policy. The broad point is that whatever has to occur during the period, which may be damage, or it may be a peril such as a fire, if that starts during the period, and assuming no intervening cause, then you will have cover for the whole of it.
So bushfires that rage for 3 months, as soon as they've hit one property, all the properties are covered.
Well, you'd have, yes, I mean, if there was one fire, I mean, we're going to come on to Lord Justice Hobhouse's fire example, because he dealt with this specifically in Municipal Mutual, but he contemplated a fire starting during the period of insurance and continuing thereafter. It would obviously cause damage as it progressed, all treated as occurring during the first period. So,
well,
yes.
I'd be better keeping quiet and letting you develop your point.
Bushfires can be trickier because there's always a debate as to whether you've got one or many within California or Australia. Now, I want to, as I said, the proposition we advance applies no matter what it is that has to happen during the period of insurance. In order to start, I wanted to look at 2 recent Court of Appeal cases The first is an insurance case concerning an event trigger, and then the second is a reinsurance case where the reinsurance contained a provision which confined the right to indemnity to losses occurring within a stated period. And that second case is Unipol-Si, with which my Lord Justice Popplewell is familiar. Can we take the first case called Various Eateries Trading and Alliance? It's in the Authorities Bundle tab 76. I'm afraid it's in my Authorities Bundle 3. My Lord Justice Popplewell has different bundles.
Yes.
So it's probably going to be in the last bundle.
Thank you.
Tab 76. Page 1987. This was an appeal from a decision of Mr. Justice Butcher in a COVID-19 business interruption case. And the appeals and the cross appeals were both dismissed. The policy provided both what's called damage and also non-damage interruption, business interruption cover. In the latter case, cover for business interruption losses resulting from certain specified causes, also referred to as covered events, occurring during the period of insurance. And if you want to see the relevant policy terms, you can see them in paragraph 17 of the judgment of Lord Justice Mayles, starts at the bottom of 1993 and goes over onto 1994. And those specified causes, or covered events, included enforced cover of an insured location and also prevention of access to insured locations. And the period of insurance, if one goes back to paragraph 16 of the judgment, one can see the period of insurance is the 29th of September 2019 to the 28th of September 2020. Now, there were two issues that were subject to appeal. One was aggregation, with which we're not concerned at the moment. The second was an issue as to the scope of cover. And that latter issue, the scope of cover issue, concerned the position where the relevant...
So where's the provision that identifies the period?
If you look at, I'm looking at 1994, so page 41 of the report, around about letter C,
Occurring, thank you.
During the period of insurance.
Thank you.
So that, as I say, one aggregation issue, we're not concerned with that. The second issue was a scope of cover issue, and it concerned the position where the relevant covered event, so either enforced closure or prevention of access to premises, started during the period of insurance, but continued beyond it. And the argument made by the insurer, Allianz, was that the insured was entitled only to recover for that part of its loss which resulted from that part of the enforced closure or prevention of access that happened during the period of insurance. And I'm going to show you the passage in a second, but Mr. Justice Butcher said, no, that's not right. And Lord Justice Mayles, giving the only substantive judgment in the Court of Appeal, agreed. If we can go through towards the end of the judgment, it's dealt with by Lord Justice Mayles from paragraph 88 onwards. So 2012 in the bundle. You'll see the heading scope of cover under the prevention of access and enforced closure causes. And you'll see at 90 the argument advanced by Allianz. Just looking at the second sentence, thus if access was to be prevented on the 1st of September 2020 and the restaurants were required to remain closed until the 31st of December 2020, only losses incurred in the first 28 days could be recovered. And if you go on, and I'm not going to read it all out, but if you read down paragraphs 91 to 93, you will see that Lord Justice Males agreed with Mr. Justice Butcher that the requirement that the prevention of access or enforced closure should occur during the period of insurance was to be construed as referring to the initiation of the closure or prevention of access. That being, as Mr. Justice Butcher had said, the meaning that would be given to the term by a reasonable policyholder. And you'll see that said in paragraph 92, just over the page at 2013, referring to the initiation of the closure or prevention. And then you'll also see, if you look down paragraph 92, Lord Justice Males endorsed what Mr. Justice Butcher had said in paragraph 69 of his judgment, in which he had pointed out some of the practical consequences that would arise if the position were otherwise. So, for example, and I'm not going to read it all out, if the enforced enclosure started on the last day of the period of insurance and lasted a week, the insured would only have cover for the consequences of the first day. You'll see Allianz's answer, which was that the remainder of the closure would fall in the next policy year. But Mr. Justice Butcher recorded that it would be quite possible and indeed probable that the insurers for the next year would exclude cover for an already subsisting closure or prevention or hindrance. And the same sort of uncommercial consequences, we say, would arise here if an insurer's argument were to be accepted. Now, my lords, we can see that Lord Justice Males quoted from paragraphs 67 and 69 of Mr. Justice Butcher's judgment. What Mr. Justice Butcher went on to say in paragraph 70 is actually pertinent. And can I just ask you to look back at that, please? It's tab 72 in the authorities bundle. Just one paragraph I wanted to look at. Paragraph 70, page 1931. And Mr. Justice Butcher poses this question. He says, the construction which I favour does lead to the question of whether, in the case of a closure or prevention, hindrance of access or use commencing in the period of insurance, there can be a claim on the policy for the interruption or interference caused by the continuance of the closure or prevention hindrance for as long as it is in place, even if it lasts for a very considerable time. V, and V was the insured, V's answer to that question was that if the closure or prevention / hindrance remained in substance the same, and if it continued to be a proximate cause of loss, then it's covered as long as it lasts. But if it becomes in substance a new enforced closure or a new prevention hindrance of access, then its effects will not be covered. And Mr. Justice Butcher said, I agree with that. And that I pointed that out to my lords on the basis that that is consistent with the submission that I made earlier, distinguishing between the continuation and development of existing damage and different damage caused by some different event or by something which breaks the chain of causation. My lords, that's various eateries. The next case I wanted to look at was Unipolsi, which is in tab 78 of your bundle of authorities. Now, Unipolsi was another case concerning COVID-19 business interruption, but this time involving reinsurance. The case was initially dealt with in arbitration. There was then an appeal to the commercial court, which was dealt with by Mr. Justice Foxton alongside another arbitral appeal. And then there was then an appeal to the Court of Appeal. And the Chancellor gave the only substantive judgment, Lords Justices Popplewell and Newey agreeing. Two issues addressed by the Court of Appeal. The first was a gateway issue concerning aggregation, and again, we're not concerned with that at the moment. The second issue concerned an hours clause and the question of when an individual loss was to be regarded as occurring for the purposes of that clause. And it's that second issue that that's relevant here. Now, the terms of the hours clause we can see is set out in paragraph 3 of the judgment, starting on page 2071 and going over to 2072. You'll see condition 2 contains a definition of the term loss occurrence, which ends up, and I'm about half a dozen lines down page 2072, it ends up by saying no individual loss from whatever peril which occurs outside these periods, and the period is 168 consecutive hours, shall be included in that loss occurrence. And the question for the court was a somewhat similar one to that which had arisen in various eateries, in the context of enforced closure of premises giving rise to business interruption, continuing for some 3 months. When did the individual loss occur? That was the question. If we go forward through the judgment, just to note, paragraph 10 on page 2073, the Chancellor explained the tribunal's decision, arbitral tribunal, which was to reject the argument that the reinsurance responded only to payments in respect of the closure of the premises during the period. The tribunal concluded, as you will see, that an individual loss meant a loss which occurs as and when a covered peril strikes or affects insured property and premises. So that's the tribunal. If one goes through to paragraph 56, page 2887, it's a long paragraph, but what you will see is that the Chancellor noted that Mr. Justice Foxton agreed with the tribunal's decision on that point. The Chancellor then went on, starting in paragraph 59 on page 2090 and running through all the way to paragraph 125, he addressed the parties' arguments on appeal. I just ask you to note what was said in 2 or 3 paragraphs, only because the Chancellor was subsequently to agree with them. If you can turn through, first of all, please, to paragraph 114, page 2103. Here, the Chancellor is dealing with submissions made by Mr. Schaff, KC, and Mr. Carr, acting for Covea, and he records their submission. The third line, a date of occurrence has to be ascribed to each individual loss. Occur in context means when did any individual loss first occur, even when it continued to develop over time. And you'll see if you drop down to 115, they submitted it's also consistent with the first principles in losses occurring during reinsurance, where the loss is attributed to the policy year where it first occurs. And then there's a reference made to various eateries which we've just looked at. And if we go through to 117 and 118, you will see essentially the same point reiterated. But if we look at 117, second sentence, the submission that the meaning of the phrase does not change depending on whether the relevant individual loss comprises physical damage losses, BI losses, or both. The phrase encompasses the entirety of the loss sustained by the original insured as a result of the relevant catastrophe striking, without differentiation. And then again in 118, a reference, or you'll see that the language, when does the relevant individual loss occur, and a reference to it first occurring within the relevant period of hours. So that was the argument that was put forward. The Chancellor's decision on this issue is that paragraphs 145 to 151, page 2110, this is the second ground of appeal, and I won't read 145 through to 148 out, but you will see that the Chancellor explains that he agreed with Mr. Schaff and Mr. Carr that the central question for the application of the hours clause was when does the relevant individual loss occur, whether that was a property damage loss or a BI loss, and he said, I agree with their analysis that occur here must mean first occur. That's towards the end of 145. Then 146. Second judgment, an individual loss first occurs when a covered peril strikes or affects insured premises or property. And then dropping a few lines down, it is immaterial for these purposes how the property or premises are affected and by what type of peril. 147, in other words, in all these cases, an individual loss only occurs once, irrespective of how long the financial loss suffered continues for. It encompasses the entirety of the loss sustained by the original insured as a result of the relevant catastrophe striking. And then at 148, this analysis accords with the other provisions of the reinsurance. It also accords, as Mr. Schaff and Mr. Carr submitted, with the first principles of losses occurring during reinsurance, where the loss is attributable to the policy year in which it first occurs. And as, my lords, you'll have seen from those passages, the Chancellor was at pains to say that the approach was the same whether the loss was a property damage loss or a business interruption loss. It was a first principle of losses occurring during insurance and reinsurance.
I mean, that's partly a result of the way the whole case was argued, because the arbitrators had found as a fact that it was a market practice that in cases of business interruption arising from physical damage, all the interruption, whether before or after the policy period, was treated as occurring when the damage first occurred. And that was the starting point. And the question really was, well, should there be a different rule in relation to business interruption from non-physical damage?
Well,
now, I entirely accept that the Chancellor's expressed it more broadly, and you're entitled to hear what to say. But that was the way the argument, in fact, developed in the case.
Well, that was certainly part of the background.
And there was a lot of debate and argument about whether actually in pure physical damage cases that the damage did or didn't all occur when the physical damage occurred, and whether the market practice was just a matter of pragmatism for business interruption or not, which was never really resolved, and I'm not sure is here being resolved by the Chancellor.
Well, no, but more market practice was certainly part of the background, but as your Lordship will see, it was put much more broadly by the Chancellor. It was put essentially as a question of construction. What does the phrase losses occurring during mean? The Chancellor went
for business interruption losses.
Well, yes, but the Chancellor went out of his way to emphasise that actually the position was the same no matter what the nature of the loss was, whether it was property damage or business interruption. And one also might rhetorically ask this question, well, if there's a market practice which treats all business interruption loss as arising on the date when property damage occurs, why should the position be any different if you've actually got, if what is continuing is the damage?
But if one takes that as what he means, it goes much, much wider than the point that you're contending for, because it would seem to suggest that continuing peril damage all occurs. My bushfires, my flood example, not your flood example, my flood example, would all be treated as occurring in the first year.
Well, we're going to come back to that, because, as I say, when we look at municipal, which we will very, very shortly, possibly before lunch, but perhaps not, you will see Lord Justice Hobhouse's fire example, and that's what he said. As I say, bushfires may be trickier, but that's the example. Anyway, those are the two cases I wanted to take you to. The next point I'm going to take quite shortly. I mean, what I really want to do is just try and test this principle by looking at cases that are concerned with different types of trigger. We've been looking here at an event trigger. That was various eateries. Unipolici was losses occurring. Bodily injury I wanted to take next, and I can deal with this, I think, fairly briefly. If you want an example of a case concerning an insurance policy with a bodily injury trigger, you can find it in the decision of the Court of Appeal in Bolton versus Municipal Mutual. It's a a 2006 decision. It's in tab 38 of your authorities bundles. Now, I can deal with it fairly briefly. We can look at it if we need to. The case concerned two public liability policies that provided cover for bodily injury or illness occurring during the period of insurance. The relevant individual developed mesothelioma, and the case concerned a dispute as to when the disease or the illness occurred, and therefore which of the two insurers was on the hook. And the argument was, well, did it occur upon exposure to asbestos, which is back in the 1960s, when one insurer was on risk, or did it only occur in 1980 when a different insurer was on risk? So that was the debate. If we want to turn it up, it's in, as I say, tab 38. Deal very shortly. Perhaps we can just, its page starts at page 971. Perhaps we can just look at the head note first and the holding on page 972. If we drop about halfway down, so just below line B, we'll see a sentence which says it was well established in the general law that words such as injury or damage in indemnity agreements did not include injury or damage which would happen in the future. Actionable injury did not occur at or around the time of exposure to asbestos, but much later, either when a malignant tumour was first created or when identifiable symptoms first appeared. Now that's the head note. You'll find the relevant passage in Lord Justice Longmore's decision, paragraph 18 on 981. And the decision was that injury occurred for the purposes of the policy at the time when a malignant tumour was first created or when identifiable symptoms first occurred, it not mattering which it was for the purposes of the policy. And that decision was consistent with the submission made on behalf of one insurer represented by Mr. Harvey that you'll see in paragraph 3 on page 976. Mr. Harvey's submission was that it was the insurer at risk at the time the disease began who had to indemnify. Now, just pausing for a second, and I can promise you we're not going to get into the Fairchild enclave or anything like that because those waters are far too murky. But mesothelioma is, of course, a cancer originally located in the pleura, but which can develop and spread, like most cancers, to adjacent organs, and which by stage 4 may metastasize throughout the chest and the abdomen. I am not aware of any case in which it's been held that a continuing disease of that sort falls to be parsed so that different losses occurring insurers on different policy years are responsible for different aspects of the same disease. And one can immediately see how it would be very difficult if that were to be the position.
In this case, the contest was between the insurers when there was exposure and the insurers when it first
You're quite right.
manifested itself, so there wasn't directly an issue.
I quite accept that, but it's an example of a decision where it was acknowledged that for a bodily injury trigger, it was the time of, as it were, first injury, what New York would call the injury in fact rule. So that's a bodily injury trigger. Property damage. So two cases that, like this one, involve property damage triggers. And they are Municipal Mutual and WASA. And perhaps we can take Municipal Mutual first. That's at tab 20. It's an appeal from a decision of Mr. Justice Waller. The Court of Appeal, Lord Justice Hobhouse gave the only substantive judgment. Now, the dispute in that case concerned a claim by Municipal Mutual, which had provided a 3-year policy of insurance to the Port of Sunderland. And it was a claim against reinsurers under 3 successive annual reinsurances. The insurance and the reinsurances all providing cover for liability for loss or damage to property arising during the period of the insurance. And if you want to see that language, you'll see it on page 45 of the report, page 385 of the bundle. So it's damage to property arising during the period of insurance. And the difficulty in that case concerned the mismatching insurance and reinsurance periods. So you've got an underlying policy with a 3-year period and then 3 successive 1-year reinsurances. Now, there are 3 points about this decision which are of note. The first I've touched on already. As a matter of fact, this was a case where there were multiple independent acts of vandalism and pilferage which caused property damage on different dates throughout the period. And if one wants to see that, one sees it very clearly from page 433, left-hand column of the report, page 392 of the bundle, the paragraph at the bottom. That's what Lord Justice Hobhouse said. Second...
Sorry, we're going a bit fast.
I'm sorry. So that's a description of the facts. And as I say, it's rather different to this case. Second point, the judge in this case at trial referred in his judgment at paragraph 74 to the passage which one sees starting on, it's on page 436, left-hand column of the report, page 395 of the bundle. The passage the judge cited starts about 7 lines down with the words, when the relevant cover is placed on a time basis, the stated period of time is fundamental. As I said when I started my submissions on this ground, I entirely accept that proposition. The third point I wanted to make about this case actually concerns 2 passages in the judgment to which the judge in this case did not refer. Now, the first of those is actually the passage which immediately precedes the passage that the judge cited. It starts at the top of 435, but if we can pick it up at the bottom of 435, so it's 394 of the bundle, you'll see, well, it's starting from, therefore it was incumbent on the judge to recognise. I'm not going to read it all out, but you will see about 6 lines down, the judge says, applying the wording of the original policy to each reinsurance contract, it's necessary to ask whether or not the relevant physical loss or damage arose during the relevant period of cover. And over the page, Lord Justice Hobhouse remarks on the trial judge's surprising conclusion that each reinsurance contract might cover liability in respect of physical loss or damage, whether or not it occurred during the period covered by the reinsurance. And he went on expressly to contemplate the same liability for the same physical loss or damage might be covered under a number of separate contracts of reinsurance. And Lord Justice Hobhouse said that's a startling result. I'm aware of no justification for it. Now, just looking at that passage, you see 3 things. You see, first of all, an acknowledgement that the judge is dealing with reinsurances providing cover on a damage occurring basis. So the contracts that Lord Justice Hobhouse was considering, essentially the same as that here. You will see his reference to the relevant question being, well, when did the relevant physical damage arise? I'll come back to that a bit later. But you then see Lord Justice Hobhouse is surprised at the idea that the same physical loss or damage might be covered under a number of separate contracts of reinsurance covering different periods. Now that obviously begs the question, when can physical loss or damage properly be regarded as the same physical loss or damage? Now on the facts of that case, it obviously could not be. In our case, the position is different. And in fact, one sees Lord Justice Hobhouse address this sort of problem in a passage that I was going to go to, but I can see the time, so maybe we have to pick it up after lunch.
Why don't we deal with it now?
Very well. If we can go back to page 432, it's Lord Justice Hobhouse's fire example, which I've probably mentioned now too many times. We can pick it up, page 391 of the bundle, it's page 432 of the report. Lord Justice Hobhouse notes that Mr. Justice Waller had juggled with two possible constructions, whether it was necessary for every item of loss and damage to have occurred within one period, or whether if there was some material loss or damage within each year, then 2 years might both be answerable. And he records that Mr. Justice Waller preferred the latter construction, and in support of that, Mr. Justice Waller had postulated the example of a fire which started before the end of a period of cover and continued after it. And then you'll see what Lord Justice Hobhouse says about this. He, Mr. Justice Waller, appears to have assumed that absent his approach to the question of construction, the assured or reinsured would in such situation be left without cover, whether before or after the end of the period of a policy year. In this, the judge had overlooked that the problem of dates in relation to time policies is not a new one, is covered by authority, Knight and Faith, Anderson and Martin. The loss is attributable to the policy year in which the loss was caused, not that in which it was capable of quantification. On the judge's example, it's the earlier year which would have to bear the loss.
Speaking for myself at 1:05, I'm not sure I see that is an answer to the continuing fire. We maybe look at Knight and Faith, but I think Knight and Faith was a case where the loss occurred in 1 year, but it wasn't capable of quantification until the second year. It's not really the same as something where there is a continuing event.
Well,
is it?
We may have to look at Knight and Faith. The word used in Knight and Faith is ascertainment, but actually if you look at the judgment properly, ascertainment was used there in the context both of loss which is discovered, but also loss which develops and is then quantified, particularly in the context of a total loss. Okay. When one sees the same passage referred to by Lord Mance and Lord Sumption, you will see that they specifically refer to development. And of course, Lord Justice Hobhouse's example of a fire necessarily connotes that you've got a fire insured peril which is continuing, but in the nature of things, your damage is continuing too.
Yes, I mean, he is addressing Mr. Justice Waller's example of a fire that continues over both policy periods.
He says
even though he expresses himself in terms of a loss caused in 1 year, not capable of quantification to the next.
My Lord, is that a convenient moment? I'm sorry I've overrun slightly to finish that.
Yes, 2 o'clock.
Call rise of April.